Welcome back to Newsday. Now, the Chief Judge of Rivers State, Justice Simeon Amadi, has rejected a request from the State House of Assembly to constitute a panel to investigate allegations of misconduct against Governor Sim Fubara and his deputy on the basis of a subsisting court order. In a letter to the House Speaker acknowledging receipt of the legislative body's resolution to set up a 7-man impeachment panel against the governor, the Chief Judge recalled the interim court order from a suit by Governor Fubara and his deputy challenging the impeachment process over alleged improper service of the notice. In the order of Justice, Fibrasima temporarily restrained the Speaker and 27 other defendants from sending any requests, resolution, articles of impeachment, or other documents or communication to the Chief Judge. We're now being joined by lawyer Oba Maduabuchi to explore the implication of the Rivers Chief Judge's action in this respect. Good afternoon. Many thanks for being here.
Thank you very much, Cynthia. And how are you?
I'm well, thank you. I hope you're doing well. Thank you for asking. Now, we understand the Constitution requires...
Yeah, no problem.
Yes. We understand that the Constitution requires the Chief Judge to set up a panel when the House presents impeachment allegations. Does the Rivers CJ have legal grounds to refuse, or is this refusal itself unconstitutional?
Now, the first thing we must note is that every order of a court must be obeyed, whether it is valid or invalid. If a magistrate convicts somebody wrongly without jurisdiction, he doesn't go to his house. They will pick him up and take him to the prison. It is from there that people will now go and challenge the order in court, and eventually he will be released and he goes home. Whether the order of Fibrasima is proper or not, whether he acted outside jurisdiction or not, whether he acted validly or not, cannot be determined unless a higher court makes a pronouncement on it. And happily, the other side, that is the House of Assembly, has gone on appeal. So the question of whether the CJ was right in saying, I cannot, he didn't refuse. He said, I'm constrained from setting up this panel because of the existence of orders. So the question should be, was the CJ right in obeying a court order? If the answer is yes, then he was right. And I don't see how the answer can be no. In the face of the prevailing court order, if I understand there are two of them, he had no options. There were no options except to say, look, I cannot do it unless and until you will set aside this order.
Indeed. Now, I see your point there. Now, there are some concerns that if a chief judge can refuse to constitute impeachment panels based on subjective assessment of requesting House's legitimacy, that it might give unelected judicial officers veto power over constitutional processes. Do you see reason with that?
I don't agree with that at all. You see, the CJ must, as a matter of, it's an imperative that he sets up a panel. He has no option. But if there's a court order that has not been set aside, and he is the head of the judiciary, I don't see how he can refuse to obey an order of the judiciary he heads. When we say executive, legislature, and judiciary, and our much touted separation of powers, we cannot sacrifice the judiciary to satisfy the legislature. You cannot sacrifice the legislature to satisfy the executive. when a matter is brought before a court, the only thing the court has to do is to look at the matter and in the circumstances of that matter, determine what is the best to be done in the circumstances. So if we want to obey the Constitution, we must also obey Section 6 of the Constitution, which gives the power, the judicial powers to the courts. We must also obey Section 36 of the same Constitution, which says, in determination of my rights, privileges against government, against anybody, I shall be entitled to fair hearing. If somebody feels something, the process leading to his impeachment is wrong, he, of course, has the right to approach the court and say, what they are doing is wrong. Like the governor has said, I was not served, or I was not properly served. Does that not ignite the jurisdiction of the court to say whether he was properly served or not?
Indeed. Now, there's a school of thought that says that the underlying issue, that this is not really about constitutional law, but it's about the tussle or the struggle between the Wike and Fubara. Now, is the CJ in this regard being courageous and principled, or would you say, if you're going to look at that school of thought, that he's been captured by one faction, whether it be the Wike or the Fubara faction?
No, Cynthia. The man has no option. Once that order of court is there, the CJ will be removed by the NJC if he acts contrary to a court order. How can you be served with an order of court which says, don't do this, don't do this, don't do that? Then because of political consideration on some other consideration, you act contrary to that order. And you are the head of the judiciary. It's impossible.
All right. Now, when it comes to the integrity of the impeachment process, we've seen a history of weaponized impeachment in our country, whether it's governors removing deputies or houses targeting governors for political reasons. Do you think we should impeachment processes should require higher thresholds or safeguards in order to prevent abuse?
No, you see, what we should do, there's nothing wrong with the law. The essence of that thing is to ensure that a governor or another officer like the president does not use the judiciary to stop his process of impeachment or removal, whatever. So the law as it is today is proper. There's no problem with it. But Nigerians should learn to elect people of integrity into their offices, public offices. There's no way a personal grounds should be ground for impeaching a governor or for removing a president. It is not assumed that because Wike is quarreling with Fubara, then his supporters will remove Fubara. Or Fubara commits an offense, then because he's friendly with CJ, the CJ will say, no, I won't set up a panel. All those things are aberrations. The essence is that the people in the House of Assembly must be people of integrity. The CJ must be a person of integrity. The governor must be a person of integrity. If all these things are in place, men of integrity, if you commit an offense and it is being probed, the CJ will have no option but to set up the panel, which they have done on various occasions. And if the governor is found guilty, in the opinion of the House, that this is an impeachable offense, misconduct, you go. I remember in my state, Enugu, they removed the deputy governor because he had chicken in his house. That's the kind of country people. In Enugu state, I remember now.
You really experienced this.
Yes, I mentioned the state, my home state. Why they removed the deputy governor? He said the governor said he had chicken in his house.
Well,
and the House of Assembly removed the deputy governor. So it's a question of the integrity of members of the House, the integrity of the governor, the integrity of the CJ. The CJ has shown that he's not somebody you can muck around with. I have a court order, and I'm obey the court order. Simple.
Duly noted.
Yes.
We'd like to thank you for your insight here on Newsday, and we appreciate your time as always. Lawyer Oba Maduabuchi, SAN, thank you so much for joining us. We appreciate you.